welcome, to this episode of Triumvir Unplugged with Eric. And it's an absolute privilege to speak with Eric once again on issues related to international law, arbitration, and allied issues relating to practice in academia. I mean, of course, we had the privilege to be taught by Eric, which was, of course, fascinating in itself. But just to give a small background of who Eric is the director of the Grotius Centre of International Legal Studies at Leiden University. He's also the chair of the ISDS Advanced LLM program, which we had the privilege of doing under him at Leiden University. He's also an attorney at law at DMDB Law, which is a law firm specializing in international law and arbitration based out of Brussels, if I'm not wrong. And he acts as arbitrators with various institutes and, participates in various, scholarly sessions and so on and so forth. So, this is just a very minimalistic introduction, I think, in keeping in mind paucity of time. But then,
I have to add here, I also had the privilege of having Eric as my supervisor when I was writing my thesis for the LLM at ISDS last year. And I think that experience is always very insightful to listen to you and to discuss things with you. And I'm really looking forward to this conversation with you today.
Not so much for me, because when I discussed my thesis topic with Eric, he said that there should be nothing called moral damages. I was very confused, because if my director thinks that there's no topic like that, then how do I write a thesis on that? But then we're glad to have you here with us, Eric. And so Eric, just to understand, you're an accomplished academician in this field and practitioner of the field of international disputes. But how did law come about? Because in India, it's a very unidirectional choice of being a doctor or an engineer or so on and so forth, right? So how did law come about in your life?
Well, thanks, first of all, for having me here. It's of course a pleasure to be part of this series. And I'm also very proud, of course, to see that two of my alumni and many others, of course, have so successfully established a practice in arbitration. So congratulations to the both of you, and thanks for inviting me. So my sort of venture into law also has to do with I guess my family, which has traditionally always been very active in law. My father is an attorney at law. My grandfather was a judge, and I come from a family where at least some of them have always been practitioners, either as attorneys or as judges or academics. I have I had in the past family members who were at the universities in Ghent in Belgium or Leuven. So I thought it was when I was young, I already had many information on legal practice, and hence it was almost automatic that I followed traces of my family members in this field, though my mother is an economist. She's a very different field.
But then international disputes as such is a very niche, was that by chance or was that by discipline,
So I here probably have to distinguish my practice career from my academic career. So when I started after finishing university in Ghent, I did a master's degree in international law at the University of Geneva. And afterwards I went back to Ghent to start a PhD research, which had nothing really directly to do with dispute settlement. It was focusing on the reconstruction of states after armed conflict. One of the important aspects thereof was economic reconstruction. And everything that relates to investment. And that's a bit how I got into the area of international investment law. But during my PhD, I always practiced as well. I was an attorney at the Brussels bar, and there my practice was mostly looking and focusing on commercial law and dispute settlement litigation before courts. in Brussels mainly. So I've, from the start, had a relatively broad, I would say, generally approach to law, considering that everything you do in international law is also influenced by what happens on the domestic level and vice versa. So I've always found both public international law, but also commercial law and litigation interesting. And then when I moved to Leiden University after my PhD, I was immediately, I would say, thrown into dispute settlement by teaching a course on international dispute settlement, at that time with the principal legal counsel of the ICJ, Professor Hugh Thirlway. Still, although he passed away a couple of years ago, still considered one of my mentors in the field of international dispute settlement. And so it's a bit of a combination of my practice together with public international law and the focus on dispute settlement, which brought me to basically combine both and focus on dispute settlement, and then more broadly investment law and arbitration, and still also everything that relates to international contracts and contract law and commercial law more generally.
So that's fascinating. I think you'd once mentioned that you coming to Leiden University in itself was something that happened to you, accidentally of sorts. You didn't know that you wanted to, come about in here, right?
Well, exactly. So the reality is that you, of course, apply to positions as they come up. You can't know a year in advance where you will end up in academia, especially in the early years, because there are not many positions that open up. And so you basically, at a certain point, towards the end of your PhD, look at positions that come up. And one of them that sort of came to my path was Leiden University. And it was actually also the only position I applied to, and I was very happy to have been offered the position almost 17 years ago. And I'm still there. So I wouldn't necessarily say it's by accident. It's probably just being open to new opportunities. And this was one that simply came along through various people I knew at Leiden University, and was for me a very successful application, and I'm very happy to still be at Leiden University.
I mean, now that you've mentioned on the fact that, how practice and academia both, curated this career, seemingly international disputes for you, which is very notable, because last year, since I came back from The Hague, I was invited to be in a panel of the FDI World Rounds. And the entire panel set of panelists were practitioners on ISDS. Okay, so, and there was a huge hue and cry about it in India that, why were no academics a part of this panel. So this is a topic of huge discussion in the subcontinent as such, the Asian subcontinent, that the practice of ISDS is very different from the practice of commercial law or, municipal law or administrative law and so on and so forth. That it needs constant dialogue between academia, development, understanding, and implementing that in practice and so on and so forth, right? This has not been the case in this part of the world, right? And so academics are really not motivated to pursue academics further because they think that, they would rather jump to, practice and this has created a really lack in academia in this field as well. And it's just a practice dominated society. Can you just, maybe shed some light on what you feel is the balance about academia and practitioners that should be in this field, to be very honest?
Yes, well, it's a very, very good question. It's not necessarily a very easy one to answer, but let me give you some ideas. So investment arbitration, investment law is I would say, if you look at it substantively, I think it's inherently an international law field. That is, the basic rules and norms are based on investment treaties. The rules applicable are treaty interpretation, state responsibility. But the practice is, of course, very much focused on arbitration. And there you, of course, have a large community of practitioners who have a commercial arbitration background. Arbitration generally, until I would say recently, but it's of course a couple of decades ago, was inherently a practice field. It's a procedure. Arbitration is a procedure. It's a way to settle disputes, which in itself doesn't say much about the types of disputes you're settling. And that's why you from the very start had very few, I would say a couple of decades ago, chairs in arbitration, for example, right? It was mostly something that was also taught by practitioners, which made sense because, of course, as I said, it's inherently a practice more than a field of study. This has changed a couple of decades ago. And what you now have to do, I think, is to find an ideal combination of academic and practitioners working on these fields. What also happens, of course, is that investment law in itself is, as we know, rooted in relatively old concepts and norms in international law relating to expropriation, the minimum standard, and of course, the rules on state responsibility. But the reality is also that the surge in investment law cases in arbitration is relatively recent. It's really only since, I would say, the early 2000s that you had a growing number of cases. And this has prompted some academics to focus on these cases, but many others have not. And this has changed a couple of years ago. And some, I would say, or academia in some states have maybe less than others followed this, I would say, very interesting legal field, simply because the state itself has had probably less cases. And I think India is maybe a very good example. India has, despite the, I would say, economic importance of the state, has had relatively few investment arbitrations. You have had some of them, of course. But it's also with the increased practice within some states that there has been a sort of academic follow-up on this. And this is where you see that some academia, scholars active in academia, have been confronted slightly more early with investment arbitration than others, and have thus taken up research in the field. I'm still considering that, especially when you look at dispute settlement and arbitration, the practice informs the research and vice versa. So there is an interesting and I think very important interaction between research and practice. I know some are a bit more opposed to this idea, but especially if you teach arbitration, as I do, I think your teaching and your research is actually very much also influenced by your experience from practice. And it's actually very important to use this practice also to convey certain messages when you look at research and teaching to students.
You know, Eric, you briefly touched upon this topic while you were speaking, but while we are discussing the interaction between academia and practice in ISDS, can we also, just briefly talk about the peculiarities of this regime itself? I mean, like you mentioned, it's a regime that is, rooted in public international law, but essentially at the end of the day, it's a private law dispute resolution system. At the end of the day, it is, deciding the liabilities or obligations of a commercial party, of a private party and its commercial interest. At the same time, it is also sort of regulating the sovereign power of a state. So it's an interesting mix. And because a lot of our listeners and viewers are going to be students of people who do not or might not regularly engage with this topic, can you also, talk a little about ISDS in that aspect, keeping that peculiarity in mind?
Yeah. And I'm someone who has, in the past, sort of been not a big fan of categorizing investment law and arbitration as something that's hybrid, in the sense that I still consider that the core of the practice and the field is, at least from the substantive perspective, is rooted in international law, especially if you get the treaties. That being said, and the program you have followed is also based on the idea that it doesn't make sense to categorize fields in an absolute way. Law and arbitration is, again, in its core international law, but it would not make sense to consider that everything else is irrelevant. National law, domestic law plays a huge role in the definition of what constitutes an investment. It plays an important role in many other questions on nationality, for example. And again, the reality of the practice is that it is very much tailored towards the existing practice in commercial arbitration. So it doesn't make sense to distinguish all the various forms of arbitration and say, well, one is commercial, the other one is investment, and the other one is, I would say, the category is interstate. Because in essence, it is arbitration. So there's a very common trunk from which you have all the sort of branches sprouting out. But this commonality of the various forms of arbitration is important. And that's why I think it's interesting precisely. And that's what makes the field a vibrant field, is that you have these different perspectives that come into play. And one can learn from the other, right? And I think this is what I find interesting is you have to be open to various other approaches to the field, be it from contract law, from commercial arbitration, from interstate arbitration, and there is a huge interaction between all these legal regimes. The older idea of it's either public or it's private is increasingly less relevant, because there are regimes where there is a cross-fertilization or where both are actually very relevant. And here you also see questions of public law, administrative law, as we call it, mostly in the European system, which is the relation between the government, the state, and usually its own nationals, is also very relevant. You have had several research being done on public law notions and how they can actually translate into investment arbitration. So it's a field that is borrowing also from other regimes, and this makes it I think necessary for everyone involved in investment law and arbitration to be also open to these various perspectives.
Yeah, thank you for that, Eric. I mean, now this also, gives rise to, I think, a very important perspective that, we were just going through an article of late, the number of FDI that comes into, let's say, the PAC region, so to say, is humongous in amount right now. Okay. And that also, is there a possibility that we foresee, the statisticians are going on saying that there will be a huge amount of rise in disputes in the global south, investment disputes, so to say. In our practice, we've seen that whenever we have been a part of, let's say, an investment dispute representing a state or an investor from the global south, we've seen humongous reliance on Western counsels, if I may put it that way, right? But with the need increasing, do you think that it is time for the global south to, increase its capability in dealing with disputes internally, so to say? So we had a guest last week, and he happened to say that it's a matter of experience. So governments gain experience over time, and that's when you have that experience to maintain and manage disputes in-house. But do you think that is the case going forward, or the language barrier in practicing international law, or, possibly not knowing French or not knowing Spanish plays a role in outsourcing litigation as such in the global south?
Yeah, well, it's a very good question. I've been myself also very actively involved in capacity building projects and training lawyers within ministries, for example, in various states to take up management of investment disputes and also settlement of investment disputes. I think it's one of the probably most important challenges in the next few years is to indeed build capacity and within the global south, sort of use a commonly used term, but which is not of course necessarily representing the entire or representative of the situation of the states. So this is fundamental. Now, as you say, there is an important question that is the question of experience and expertise. You need, of course, and this is valid for investment arbitration, but also for any other fields, law of the sea, WTO law. You need expertise in the special features of the regime. And especially if you have arbitration or dispute settlement, experience in settling disputes is, of course, fundamental also. This is, of course, a question of time. And this is a question of how you can involve local teams, either law firms, but also within ministries, within the Attorney General's office, in dispute settlement, in arbitration, who then at a certain point will, of course, be able to take over very simply. And you see it in what we typically call the famous sagas in investment law arbitration. The Argentinian cases, the Spanish cases, they have an impressive in-house capacity. They have their own teams who deal with these disputes. It wasn't necessarily the case in the early cases against Argentina, for example. They relied on external counsel. They don't need external counsel anymore. They're well placed to do it by themselves, and there's no need there to rely on external counsel. Now, this depends, of course, on the number of disputes you have. The less you have, I would say, the better it is generally for both parties. The more cases you have, the easier it is, of course, to gain experience and on the field. Now, the question of language is also important. I think if you look at the practice, you have three main languages, English, French, and Spanish. I would actually say that Spanish more than French nowadays. If you look at the number of cases involving
Latin American countries, I think that's also because,
Latin American countries, Spanish has become, I would say, in the practice of investment arbitration, the second language, if not almost equivalent to English. I wouldn't say you still have many more cases in English, but there are a lot of new cases that are brought in Spanish, and you still have cases in French also. So there is, of course, the language question. Now, this is something you can work on. There's always, of course, if both parties and if the documents are mainly in one language, it probably also makes sense to use that language for the proceedings. And this can be English, French, or Spanish. You see also sort of more hybrid forms where documents need not be translated. And this is, I think, very good because this is one of the huge costs for investment arbitration generally, where you basically agree that documents need not be translated unless there is disagreement on the meaning, and therefore you can specifically translate certain aspects, certain parts of a document, for example. But this also requires arbitrators to be well versed in at least two languages. But you see this happening in practice.
I think it's also very situational because in the last 2 years, we have seen a lot of disputes coming out of Russia and Ukraine, and we have seen a lot of requirement for lawyers who speak languages, which would be useful. I think because Latin America has a lot of disputes in terms of the volume, there has been a rise in the requirement for Spanish-speaking lawyers. But if we look at Asia Pacific, we do not. So the countries in Asia Pacific, I feel, are little. On the outlier, because we generally do not straight away go for investment arbitration. We, even in the last few years, we have seen that a lot of these new model BITs that have come out of this region, they have laid a lot of emphasis on other forms of dispute resolution, mediation, conciliation, national courts, so on and so forth. And arbitration, investment arbitration has generally been the least preferred option. Even then, if this part of the world, for example, goes into arbitration, English more often than not is the language of choice. The documentation is mostly in English. There would be very few examples where a local language is the preferred language. So I think that's also part of the reason why lawyers from Asia Pacific, if I can say, generally focus more on English and not on other languages, because the local requirements are such. We need not, I think, necessarily go in that direction. But yes, if you look at the larger picture, I think that is one of the reasons why we don't see a lot of lawyers from India, from Asia Pacific on the international law scene because of the language barrier.
No, but there's a plus side to it also, because So, for example, we do a lot of work in the Middle East
In the Middle East.
because
yes.
of our English capabilities.
Yes, correct.
So, and
Correct.
the Dubai, let's say Saudi, Qatar, they hire a lot of Indian lawyers because
Absolutely.
of English capability. So, while there are upsides to this and there are downsides to this as well, I guess.
So I was talking more in the context of ISDS and not commercial arbitration, because commercial arbitration, like we have also seen, we have worked in Hong Kong, we have worked in Egypt, we have worked in the Middle East, and English has been the language everywhere.
You still have many cases, many investment arbitrations are conducted in English. I think the majority still is in English. And of course, you have countries like India, Singapore, where English is the commonly used language. So this is, as Anubhav explained, I think also a plus. I mean, you have legal education in English. I mean, that's clearly an advantage, I think, compared to others as well. Now, of course, the relevance, I would say, of French and Spanish for most countries in Asia, for example, is less, because your working language is English. You're not probably easily confronted to counterparts, companies that require knowledge of another language.
That's
In the sense that they would not be able to communicate in English because they want French or Spanish, or Arabic or Chinese or Russian. So there is, of course, a reality that English is in today's world the most commonly used language for international transactions.
One good thing that came out from our LLM class is also the reciprocity between our classmates, because since our firm, we do a lot of work with our Chinese classmates who are there, so that's fantastic. But what in that part of Asia as well, there is this very, very specific language requirement, and it's Mandarin, and it's very, very specific, and most of the disputes as such in Mandarin. And even when they enter into doing business in India, we've seen, we've worked with a few of them in assisting them in doing so. Every documentation, everything is in India, so we need to get it translated, apostille, everything. So we're very, very territorial in terms of language. So this particular geographical area is also very divided in terms of language. And the two major players, China and India. So yeah.
Yeah, no, I agree. The language question is of course a very important one. And it's also something that's inherently cultural and state specific, right? So there's also not necessarily much you can do about this, except saying that language is important, especially if you want to work abroad or with companies abroad. You have languages, and you can look, of course, at Chinese. That's, of course, China specific. But on languages, I'm a native French speaker, but my second language, which I learned from the very start in Belgium, was Dutch. Dutch is also of limited relevance. Its relevance to Belgium, the Netherlands, and Suriname, basically. So, yeah, I mean, this is again very cultural, very state specific, and I can only encourage everyone to learn at least the second of the major languages.
Well, Eric, I mean, in hindsight, I truly believe that, it would have been perhaps better if I had learned French or Spanish a couple of years ago. It's still something that's still on my plate, and I want to take it up at some point. But yes, it's there, and I think I agree. People should, as a norm, try and learn one international language apart from English and the native language. I want to talk more about the particularities of the Asian Pacific region, but before I do that, I also want to briefly touch upon the topic of reforms in ISDS, because over the last few years, a lot of discussions have gone on. You have been a part of some of those discussions. We have attended those sessions at the working group 3. And I think early this year, there was some sort of consensus about an advisory center. So I just want to get a first person's point of view from you and, understand how the process is going and what reforms can we see going forward, and how do you see them impacting ISDS regime and making it better?
Yes, very good question. Now we're as you said, we're in an area of huge reform proposals, and I'm since last year representing the Belgian Centre for Arbitration and Mediation called CEPADI, who is an observer at Int'l Working Group 3, also in Working Group 2. So I've been following I've been following it from I would say a bit more distance before that, and now more directly. The reform agenda is quite impressive, and there are a lot of questions that are being discussed. We typically focus a bit more on the reform of the method of settlement, which was the idea to replace arbitration by a standing disputes tribunal coupled to an appellate mechanism. There have been many other questions that have been discussed, and you mentioned one of them, the creation of an advisory center, which is actually was agreed, I think, in the last session in Vienna and sort of confirmed in New York, March or April this year. So this is a very interesting and very good way forward. It's a new international organization that will be set up. They have to agree on the specificities of the statute. Still, the bulk of the work has been done, and the idea, of course, is to create an international organization which can provide assistance to mostly states by providing training, but also advice and counsel for these states that require assistance in these matters. The big question, I think, next question is the reform of the methods, and so the creation of a disputes tribunal and an appellate mechanism. This started only there is a draft, but the discussions of the draft started only in the last session of New York this year. So this, in all likelihood, will still take some time. That is the agreement on the draft statutes. And then, of course, the big question is the entry into force of all this, and whether you will indeed, once you have agreed on the statutes, have all states. The idea is basically that you can register, so to say, your investment treaties to the disputes tribunal, to the secretariat, and if both states to be have done so, then basically the disputes tribunal will replace arbitration. Now, of all this, of course, entry into force, ratification, submission, registration, agreement of the two, or submission by the two parties to this all will take time. Now, I always I find it difficult to predict when this will all happen. I have a couple of principles and rules that I apply for myself. Is one, not to predict what the ICJ will decide in a couple of cases. And secondly, is not to predict when investment tribunals will replace arbitration. It's only time will tell how this will proceed. It's not necessarily something that will happen very fast, but again, it's very difficult to predict. There will be some changes. That's inevitable. The only question is when they will enter into force and be therefore used in practice.
So that's fair, because we only saw that, the whole idea of ISDS taking about 40-50 years to be accepted at large as a practice area. So any transition to that would be, I think we had written a paper on reforms for your course itself, and I remember I think I remember coming with a very interesting article by Jan Paulsen on reforms, and he concludes by saying that you can write and deliberate thousands of times on what can the reforms be and what can be, but at the end of the day, it's the arbitrators who decide. And so the important question should be, how can you make the arbitrators more uniform rather than processes?
I would say the reform proposals now discussed in the multilateral fora. So you've had ICSID that finalized 2022 new rules on arbitration, which with quite impressive procedural reforms, not on the method of settlement. There is, of course, the ICSID convention is based on arbitration. So, of course, they follow arbitration. So it's more procedural. They did add new rules on mediation of investment disputes, for example. on fact-finding also, there were some reforms. Now, this is the multilateral track, as I call it, and it's very much focused on procedure. Here and there you have some substance that sort of is blended in. The other reform, which is also taking place, but more bilaterally, is on substantive questions. And there you see that states are engaged in changes with new model BITs, and the Indian model BIT is an important one, but also in other multilateral or plurilateral treaties, such as the TPP, for example. You also have the treaty signed by the EU, which have made some modifications. So there's also, I would say, substantive reform taking place on a more bilateral level. And you have to combine both of them to look generally at how the field will evolve. But all this, again, is something that is a bit difficult to predict when you have a sort of combination of these two tracks at a certain point.
So I think one of the ideas behind having an advisory center was that it would promote some sort of predictability in terms of how standards of prediction are interpreted by tribunals, because we know that the tribunals are not bound by earlier decisions or earlier awards. And I think that's also part of the reason why there has been so much discussion about an appellate court or a standing court or permanent standing institution. But this discussion of predictability also makes me think about the fact that, of late, like you mentioned, we have seen different forms of BITs now that are coming out, and the standards of prediction, and I'm talking only about, BITs that I've seen in the last few years coming out of Asia Pacific region. Now, a lot of these BITs I've noticed have sort of cut down on the standards of prediction, or have explicitly built in exceptions, whether it is environment, health. I think Japan and there's a BIT that Japan entered, I think, with Georgia, which also includes labor exception. So the BITs coming out of Asia have now expanded the restrictions on standards of protection or exceptions to standards of protection. And I think that can fundamentally alter the way we have seen tribunals decide in the past. We saw in Argentina cases, for example, there were tribunals that accepted national security and tribunals that rejected the argument of national security. But with the changes that are happening in Asia, I think with a concerted effort, now Asia can, in the next 10, 15, 20 years, when these disputes come up, even if they go to arbitration, because there's a lot of focus on mediation and conciliation, but Asia can significantly change the way the tribunals till now have interpreted certain standards, because at the end of the day, it's about the interpretation of the standards and nothing more.
Yeah. So I think this evolution takes place in Asia, but not only in Asia. The European Commission, of course, has changed some of the provisions it's including in its investment piece, and it's actually transpiring to the BITs that are signed by the member states of the European Union. And you see this evolution a bit everywhere. Now, I think it's probably inevitable. So you still remember this. I'm not necessarily someone who's convinced that there is a lack of coherence in investment arbitration. There are the occasional problems of lack of consistency, which is fact. You have certain cases where the same treaty was interpreted differently, or cases where the same facts applying treaties with similar provisions were also resulting in different outcomes. I think these are relatively minor compared to the bulk of decisions that are out there. I think it's probably up to the states to do what they are doing. That is, if you disagree on how arbitrators have interpreted a certain provision, the best and easiest and probably most obvious way to deal with this is to make clear in the next treaty what you intend this or that provision to mean. And that's why you have the exceptions coming in, the exclusions that come in, the reformulations that come in. Now, at the same time, it's also probably naive to think that you can cover any type of dispute with reformulating certain standards. So you will always have questions that come up that are not explicitly dealt with in the treaty. And this requires interpretation. That's inevitable. It's the same for contracts. You cannot predict every single dispute, every single instance of disagreement between the parties. So it's inevitable that arbitrators will have to interpret, well, exactly what did you mean by this provision? And states do not always have the same understanding of what they put in the treaties. It might well be that you have a provision that is the result of negotiation between states, but where in the end you might consider that, if we take India, in a potential PIT with Belgium, for example, that though they agree on the formulation, they still might not consider, if they would interpret the provision, come up, or they might not consider that the interpretation of that is exactly the same. And I can then imagine that there's an arbitrator or an arbitral tribunal decides that this could be a certain way. One of the states will not be happy because they had actually considered that it would be otherwise. But then again, you can react to this, right? In future investment treaties. And this is, I think it was James Crawford who explained this at a certain point. I think it was a very, very good explanation. This is only natural. There is always an evolution in norms, and it's always the result of states adapting to certain realities, to certain decisions. This is a normal way of evolution in legal regimes. And you see it happening here also.
So, I think last week or 2 weeks back, India came out, the government came out with a new circular. It applies more to domestic arbitrations, commercial arbitrations, and not investment arbitrations. But basically, what was decided was that, given the number of awards that tend to go against sovereigns or against states in arbitrations and the costs involved, there has been a renewed focus on using conciliation and mediation as the preferred form of dispute resolution when it comes to commercial disputes, whether it is a domestic arbitration or international commercial arbitration. Now, if we equate that model to investment treaty, to ISDS, and like I said, and we spoke about it, that now there's a lot of emphasis on other modes of dispute resolution. Where do you see arbitration as a method of resolving disputes in ISDS going forward? Because the focus, and I keep talking about Asia again and again because the focus of the podcast is sort of on the Asian practice and the trends in Asia. And I'm sure it's happening all over the world or across the world. And now states are starting to realize that arbitration might not be the most conducive form of resolution for them. But this focus on conciliation and mediation that we see now, how do you interpret that, and where do you see arbitration going from here?
Yeah, it's a good question. You see the huge move towards the use of other forms of settlement than arbitration. And conciliation has been part of the ICSID Convention since its very inception. The reality is that it's not very often used. I think the main reason for the lack of enthusiasm about conciliation is that it is a relatively formal and heavy procedure nonetheless. And you're still in the end left with a report of a commission that is not binding. For that reason, my impression is that parties prefer, if there is a formal procedure, to take arbitration and then in the end at least have a binding decision. Now, the good thing is that, and this is also what ICSID has done in 2022, is adopt new rules on the mediation of investment disputes. So there is probably, and we'll see it in the next few years, also with the Singapore Convention, which makes life easier to enforce the agreements resulting from mediation. We might have a bit more of the mediation in this area. I think this is also something that we have to wait and see. I think arbitration still has a lot of value in the sense that you do have a procedure that is relatively swift. Say relatively because the average, I think, is still above 3 or 4 years, which is quite a lot. But you at the end have a final and binding decision. Mediation is very helpful, but if the parties are already in such a situation that they're not necessarily willing or not in a position to talk to each other to find a common agreement, mediation will not be very helpful. So you see more discussion on multi-tiered mechanisms of settlement, where you start by mediating, and if it doesn't work out, then you move to arbitration. So this is something that mediation has happened more in the commercial context than in investor-state arbitration. One of the, I think, main reasons or explanations for also the lack of use of mediation is that the measures you're dealing with in investment arbitration are very often of such nature that there's no easy solution to be found by agreement of the parties. If you have an expropriation, for example, and you disagree on the amount of compensation, you have already negotiated and you disagree. So that's probably why also mediation will not necessarily be very easy. Same with the question whether there is an indirect expropriation. You very often have a mandatory amicable settlement in investment treaties. That's sometimes, there is an attempt, sometimes there's not. It's very often an attempt. But you see that these mostly fail in cases. At the same time, we also have to keep in mind one important thing is that of all the investment arbitrations brought, a large percentage is settled before the outcome reached. So there is, and this is something we tend to forget, once an arbitration is brought, there are still negotiations going on.
Yeah.
These are the those that make it to arbitration and proceedings conducted are probably those where amicable settlement and then also mediation probably will not have been helpful. But mediation may be helpful to increase perhaps the number of disputes that are settled before they actually make it to the final decision in arbitration.
You bring out a very interesting point that arbitration is possibly irreplaceable, at least in the near future and the near foreseeable future, so to say. If I'm being very considerate as well. But then there becomes a huge challenge of, so when we deal with investment treaty arbitrations, for example, enforcing an award, an investment treaty award in India is a challenge.
Quite a challenge.
If not anything else. Because we have had two different high courts having interpreted the enforcement provisions differently. Whereas, for example, I'm just saying one high court says that, our Arbitration Act specifically says that in relation to commercial disputes, and we've made that reservation in the New York Convention. Whereas the other high court says that the overarching vision is to solve a dispute and it's an arbitration. And we should be able to, it's a very pro-arbitration situation. But, when we see Singapore, it completely does away with this because Singapore has a specific legislation for investment treaty arbitration. How important do you think is for states used to have to enforce, to give assurance to investors, in addition to protection, is to have a specific enforcement provision legislation, so to say?
Yeah. Well, it's a very good question. So last week I was in a conference of the American Society of International Law called ISDS abroad in Geneva, and I was part of a panel on enforcement of arbitral awards. Now, everyone agrees that it's sometimes easy, but very often not easy, because you're, of course, dealing with a state, you enforce against states, hence questions of immunities come into play, and you have indeed if you look at non-exit arbitrations, you have the set-aside proceedings, and you have, of course, proceedings relating to the recognition and enforcement. And although the New York Convention is created a relatively uniform regime, this all very often needs to be or has been implemented in certain states, and you have, of course, legislation that differs. So enforcement is a big question. It's an interesting question, and it's not an easy one to answer. I think ideally, of course, you enforce decisions relatively rapidly, but it's become increasingly difficult because some states refuse categorically to pay what they should pay under an award. Sometimes they're successful in set aside or even in not with an exit. Sometimes they're not. here also, I think the reality is that a lot of these cases are also settled even at the enforcement stage, where you find a common agreement on the amount to be paid. Can be less. There might be other questions or forms of restitution or new business opportunities that might come into play. This is something that is, of course, to be negotiated between the state and the investor. But it's a big question. There's no easy answer to this. There are many challenges in that area. Also because the amounts at stake are relatively high. So for some states, amounts to be paid are the equivalent of a budget of the whole ministry, for example. There is, I think, also financial difficulty for some states to really effectively pay these. And the question is then, well, what can you do? Well, there's no easy solution to all this.
Right. I mean, and, with that, I think we would come back to, having touched bases on most of these questions in relation to practice. In India, the sole ambition is to, when we graduate, you've dealt with a lot of students, I'm sure, from this part of the world. And, there's mostly a bi-directional approach to careers, right? Like that's either being a corporate lawyer, M&A. So at our firm also, a substantial percentage of our practice is mergers and acquisition, private equity, because that's the mainstay. And then you have the dispute resolution practice, right? So there has been a stark change in that. Of course, you've seen that. You've seen a lot of people, coming to study, international disputes, working in European law firms, gaining first-hand experience of such disputes in, so on and so forth, right? But still now there is, the whole topic of international law, or ISDS, is not a common room discussion or knowledge even for law students as such. So, you as the director of, or the chair of the Leiden program, which is, in my personal opinion, one of the finest programs that is there to offer in this, and which is super specialized, right? Like it's super specialized in an advanced master's, right? How is that, equipping lawyers for this field, in which we are only going to see evolution?
Yeah, well, it's a very good question. I think there are not many law firms who only do investment arbitration. Most of them are indeed involved in various other forms, which I think makes a lot of sense. So part of my practice is also commercial arbitration. Practice also public international, generally questions related to sanctions, for example. And then the part is investment arbitration more specifically. I think what is important as the program is built on this idea is that you have practitioners that are actually, or academics that are interested in dispute settlement and arbitration, that sort of keep their background in corporate law, in contract law, in international law, but want to further specialize in the way in which these disputes are settled. But again, one does not necessarily exclude the other. I think the whole idea of the program is also based on the fact that we want to look at dispute settlement and arbitration as a whole. That is, as a way to settle disputes, whether they're interstate, contractual, commercial, or investment. And I think, again, dispute settlement and arbitration is a method of settlement. It doesn't say much on the substance. So we only have a couple of courses in the program, which you probably remember, that deal with substance. It's principles of international law, trade, organization law, investment law, because it's inherently tied to the way in which the disputes are settled, which requires knowledge of the field. But I think it's actually very interesting precisely to have a broad approach, which what you do in M&A, in contracts, is always very relevant for disputes, whether it is in the investment context or in the commercial context. I think one important point that we all have to keep in mind is that a broad approach to law is always interesting. Exposure to various legal regimes, to various disputes, is always interesting. It's never not. Always brings something to your experience and expertise. And that's why I also always tell my students, well, if you want to do investment arbitration, if you want to do arbitration, build experience in law, fields that are of relevance, right? In commercial law, in contract law, in international law, in investment, in finance. All these areas are always very relevant, whether it's in a domestic system or even in another system. So if it's in India, or if you work in London or in Paris, it's always very
because most of these disputes emanate out of commercial destabilizations as well. And this takes me back to our Paris visit last year, where we had, I think, one of the law firms that we visited, there was a partner at one of those law firms during our Paris visit. And I had the chance to converse with him during that visit. And he mentioned that, there are firms, big firms, which often tend to super specialize, you have investment lawyers, you have corporate lawyers, you have domestic lawyers, and so on and so forth. But according to him, back in the day, that wasn't the case, because for you to be a good corporate lawyer, you need to understand how not to go to court. And, for you to go to court, you have to understand how transactions work, to be very honest. And I think that's a very fair point, because if I'm going to court, if I don't understand a shareholder's agreement, right, what comes out of it, what are the requirements as per law, what is a right of first offer, what is a right of first refusal, those are disputed clauses, it becomes problematic. But yeah, I mean, it was such a fascinating conversation with you as usual. And we're so grateful to have you with us. I mean, I think within this period of 1 hour, I think we touched on so many issues. We would have wanted to, obviously, you're on mute, Paris, if you're trying to say something. I mean, we wanted to talk so much more. And yeah, thank you so much for joining us.
Thanks for having me. It was a very interesting discussion. So I'm very happy that you asked me, and who knows, we might do a follow-up at the next time.
Definitely.